over the past couple years, ever since the 2022 New York Rifle and Pistol Club versus Bruin case in the Supreme Court was declared constitutional carry from coast to coast, I have argued that because of the statements that were made in that case by the judges, particularly Clarence Thomas, that all Second Amendment laws are actually unconstitutional based off of that decision because of what was said about historical context. Essentially, it was said that the Second Amendment must be consistent with national history of firearms. In other words, you have to look at what was going on in the moment that that Second Amendment was written with the case of firearms. What restrictions were in play in that moment? Historically, well, historically, there weren't any. There were no restrictions at all. The only real restriction was declared by the Crown before we got our independence of England, ultimately saying that citizens of the colonies were not allowed to intimidate other British citizens in the streets with guns. So that was really the only gun law that was written at the time. And that wasn't even a U.S. gun law. That was a British gun law. And even if that one applies, so you can't intimidate somebody on the street with your gun, makes sense to me. You shouldn't be able to do that. I'm pretty sure that is the law. But the reality is historically there were none. And now a federal judge in Kansas agrees. According to the case, federal judge John Broom, in the case U.S. versus Morgan, has declared that machine guns are constitutional, that we have the right to own machine guns because there was never any restriction on machine guns. There's never been a restriction. If you look at the Supreme Court case, the Bruin case, and you just simply apply that case, all Second Amendment restrictions are unconstitutional. I said this 2 years ago when they first said this, but of course they doubled down on the anti-constitutional restrictions. But this federal judge, Judge Broom, has literally said and declared, because of the New York Rifle and Pistol Club versus Bruin case, the Supreme Court, which declared you have to look at historical context of firearms. Based on that, there are no restrictions of firearms that you can own an automatic weapon because of what was declared in the Supreme Court case. Now, will this stand? Probably not. But it's nice to see that other judges are actually saying, well, wait a second, the law says this. The Supreme Court said this. It has been declared that if you look at historical context, you have to apply it to Second Amendment restrictions. And at the time, there weren't any. And again, the only one you could probably argue there was is just don't intimidate people with your guns on the street. Other than that, all Second Amendment restrictions are unconstitutional. Not some of them, all of them. So, there we go. Again, I'm sure this isn't going to sustain anything. I don't think it's going to amount to much other than I believe these things have like a ripple effect, that the more federal judges that start to say, well, wait a second, according to the Supreme Court, if we apply historical context, there were no gun restrictions. And this is very significant. This ultimately says that all anti-Second Amendment laws are unconstitutional, according to the Supreme Court, and now according to federal judges. So there you go. Any thoughts or insight on any of this stuff, definitely put it below. Do want to take a moment and say most people watch this channel, not subscribers. Click that subscribe button. Greatly increases the algorithm and our ability to get these messages out. That link is below. But the most important part of this channel is we take prayer requests. So please don't ever hesitate to send that stuff in. Thank you for watching this episode of God, Family, and Guns. And as always, love God, love your family, and love guns.